Hello friends, in the series on the income tax cases, today we will discuss a very important case. The name of the case is Principal Commissioner of Income Tax versus Trump Realty Private Limited, and this case has been reported in 450 ITR at page number 271. The matter has been decided by Delhi High Court and the date of the judgment is 31st March 2022. As all we know that in Income Tax Act, only the revenue receipts are taxable, capital receipts are not taxable. Similarly, if we go on the expenditure side, only the revenue expenditure which are done on the day-to-day basis are allowed, and the capital expenditure are allowed only in the form of depreciation or amortization. More or less, now there are very few items which are termed as capital receipt, because mostly whenever any income arises to the assessee, it is a taxable income. But in peculiar circumstances, it may happen that some income is received by the assessee, even the TDS is deducted on that, and in that case also sometimes the receipt is a capital receipt. This case is the perfect example of this type of item. In this case, the assessee took an external commercial borrowing loan of 83 crore rupees. The whole amount of loan was disbursed to the assessee in the year ending 31st March 2012, and this loan was acquired to purchase the fixed assets. In the financial year 31st March 2012, near about 33 crore amount was utilized for purchasing the fixed assets, but the rest of the amount was not utilized during the previous year 31st March 2012. So the assessee, as a prudent businessman, invested this amount into the fixed deposits of the bank, and on that fixed deposits during the financial year ending 31st March 2012, the assessee received an interest of rupees 4 crore rupees. The external commercial borrowing loan which was taken by the assessee, the interest cost on that loan was 12 crore. So in this case, what the assessee did, the assessee capitalized the net amount, that is the interest received minus the interest paid, or you can say that 12 crore interest which was paid and 4 crore the interest which was received, the balance 9 crore was capitalized by the assessee. Because the fixed assets were not acquired completely, and this loan was specifically taken to acquire the fixed assets. But the assessing officer was of the view that this 4 crore is a revenue receipt and it should not be capitalized, or it should not be deducted from 12 crore. Basically, the main motto of the assessing officer was to tax that receipt as a revenue receipt. But it was the version of the assessee that this is not a revenue receipt and it should be deducted from the interest paid on the loan which has been acquired for purchasing the fixed assets. When this matter went to the ITAT was of the opinion that it is not a revenue receipt, it is a capital receipt, and it should be reduced from the interest cost which has been acquired for purchasing the fixed assets. The department was not satisfied with the order of the ITAT, so the department preferred the appeal before the Delhi High Court, and the Delhi High Court held that the question whether the interest received is a capital receipt or a revenue receipt is not a substantial question of law. So whatever the decision has been given on the facts and circumstances of the case by the Delhi ITAT is justified, and the Delhi High Court declined to interfere into the order. Friends, in this case the TDS was deducted on the interest, so only the fact that the TDS has been deducted does not make that amount or the receipt as a taxable receipt. The true nature of the receipt is to be taken care of, because the loan was acquired, the loan was taken to acquire the fixed assets. That is why the interest received should be deducted from the interest paid and the net of the amount should be capitalized. So whatever the treatment has been done by the assessee was correct. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Trump Realty Private Limited, and this case has been reported in 450 ITR at page number 271. The matter has been decided on 31st March 2022. Thank you, friends.